Hello and welcome to today's Cordium AIFMD Surgery Webinar focusing on the Alternative Investment Fund Managers Directive and the role of the depository. My name is John Wilson. I'm Project Director at Cordium. First of all, I'd like to introduce the panel today. With us around the table we have Bill Prew, who is the founder and CEO of the independent AIFMD depository INDOS Financial. Prior to INDOS, Bill was the COO of James Caird Asset Management, and prior to that worked for many years at Barclays Global Investors in roles which included European CFO and Head of Supplier Management. Prior to BGI, Bill qualified as an accountant with PwC. With us also is Emma Stevens. Emma is part of the global hedge fund consulting group for EMEA at Goldman Sachs. She joined Goldman in 2002 as part of the equity compliance team and moved to Head of Prime Brokerage compliance team in 2006. Emma then transitioned to the consulting team at the start of 2010, which focuses primarily on regulatory issues and operational due diligence. Also with me is Bobby Jahal. He's management consultant here at Cordium and has taken much of the technical lead on AIFMD and in the development of Cordium's AIFMD compliant infrastructure. Now, in a few moments, I'll be asking Bobby just to talk around some of the implications for the variation of permissions that firms are going through in relation to depository. And then I'll hand over to Bill and Emma, who will talk through some slides covering some of the practical aspects of selecting the depository, particularly in the hedge fund space, and determining the service level that's right, service arrangements that are right for their firms, the FCA authorization, and the fund structure. And they'll also be considering some of the implementation issues for onboarding. Now, throughout, those of you familiar with some of our webinars, we've been running polling questions, and we're going to be doing that today, which is an opportunity where we'd like feedback to some of the depository-related questions. None of these polling questions are meant to be statistically representative, but they do tend to indicate where you may be with the selection process and give some idea of what the community is, where they're positioned in this process. And if the questions are relevant to you, then please answer, and then we'll take the feedback. We'll be reviewing most of the polling questions at the end, but we will be coming to one shortly, which we'll use to kick the proceedings off with. Now, importantly, as this is a surgery, it's very important that you can send through questions and concerns that you have around the AIFMD depository arrangements, and perhaps around the implementation process or the options for depositories that you have. And so these questions will help drive the second half of the webinar. At any time, please feel free to submit your questions through to the question panel through the GoToWebinar application. Those questions will be received centrally here, and our panel will take time to address them during the webinar. And we think that questions get maximum amount out today, then please send the questions through, and we will seek to deal with them. Now, the FCA wants to receive AIFMD applications for variation of permission within the next 27 normal working days. That's less than 6 weeks. Now, before I hand over to Bobby, we had one polling question which came up from the webinar about 4 weeks ago now on variation of permission. And the answer should be on the screen now, which is whether or not firms had seen a draft depository agreements. And the indications were that most of the firms had not seen the actual agreements at that time, which suggested even then that firms had not got, or still had some way to go with negotiations with service providers as to what their depository arrangements would be. So, given that this agreement issue is key to the variation of permission, Bobby, could I ask you just to comment on some of the issues relating to variation process specific to the depository that firms are seeking to address now?
Of course. Thank you for that, John. Okay, well, just to be clear, the process will of course differ in the different EU jurisdictions. So the majority of firms seeking to apply in the UK by the FCA's first stated deadline of 22nd of Jan 2014, one will need to identify the depository or the depository services provider for each AIF in Section 9 of the variation of permission application. It is possible to submit the variation application before a service provider is actually appointed, but not, of course, possible to conduct authorised business unless one has actually been appointed. So at the point of submitting your applications, firms should, however, be sufficiently advanced in their contractual discussions with your depository providers, and confident that those arrangements will, of course, comply with the AIFMD, needless to say. The FCA will insist upon confirmation of those contractual relationships at least 1 month before the date on which the AIFM intends to begin managing an AIF. This is in reference to the idea that one can defer authorization on the directive. At a given date, many firms will perhaps be electing to become authorized as such towards the middle of next year, so June, July time. But as I say, at least 1 month prior to the date on which the AIFM intends to begin managing an AIF, you need to have those confirmation of contractual relationships organized. But a note of caution, for existing firms managing funds under the transitional, the FCA has warned in a very recent news update that management of the AIF may be suspended if depository arrangements are not finalized. So really a key deadline that's emerging now is the 21st of June 2014 deadline. And as part of the review of your authorization, of your application for authorization, the FCA will seek confirmation that depository firms are willing to act.
Okay, thanks, Bobby. Probably just before you move on.
Sorry, big bottom. Sorry, I thought there was a following question, but let's continue to the next slide just for a moment. So when one comes to actually completing the application, managers planning to rely on reverse solicitation should articulate their reasons in the regulatory business plan. To be clear, reverse solicitation cannot be considered a marketing strategy. The whole idea is that the firm is not marketing, of course. So we'll go into in the slides that are forthcoming, we're going to explain a little bit more about how these requirements are switched on and off by the fact of your marketing intentions. But to be clear, one does not need to appoint a depository if one is not marketing in the EU, for a non-EU fund, that is. So opting into depository-lite at a later date is an option, but that will require notification to the FCA before we go ahead and do that. Of course, practically speaking, there will be a capacity constraints in the depository markets, and firms really should not leave the identification and appointment of providers too late. There will be a large number of funds, of course, onboarding between now and July, and some depositories will probably start on board well in advance of that deadline. And as part of the application, of course, an AIFM will need to demonstrate that they've performed some due diligence on the selected providers and be prepared to share this information with the FCA on request. INDOS, Bill's firm, has kindly shared with us, has devised and shared with the manager's depository selection checklist for us to then share with our clients. So thank you very much for that, Bill. Very useful indeed.
Okay. Before we just go over to Hannah's bill, we've got one polling question which we just want to ask the participants straight away, and we'll just sort of get the responses. And the polling question should be up on your screen any moment now. The question relates to the state of readiness, really, or the time needed to get yourself operationally compliant. For this. And the question is, what do you think is the time required for your firm to be operationally compliant with your preferred depository? And the list of options are less than 2 months, 2 to 4 months, 4 to 6 months, or over 6 months. So there's an opportunity now just to respond to those. Have we got a problem? Do we need to move on? Okay, let's just move on. I think we've got a technical problem with the polling question.
That's right. Shall we go to this recap of AIFMD depository requirements?
Thanks, Bill.
Shall we just keep moving on? We can always come back to the polling questions. So really the depository requirements are driven by a combination of domicile of the speaking AIFMD language, but AIFM, the Alternative Investment Fund Manager, and the Alternative Investment Fund, the AIF, and to a degree marketing practices. So there's 3 categories. Obviously, if you've got an EU AIFM of an EU AIF, it's subject to the full depository requirements. We're going to cover that a little later on. If you've got an EU AIFM of a non-EU AIF, which is probably the lion's share of the European hedge fund industry, then they're subject to a lighter depository regime. But as we mentioned earlier, only if the non-EU AIF is being marketed to EU investors through private placement. So we're going to cover each of these off, or those two off it in a second. And then if you're a non-EU AIF, it doesn't matter at the moment whether it's an EU or non-EU AIF, you're not subject to any depository requirements under the Directive, given that this is Article 42 of the Directive, which governs non-EU AIFM. But there are some countries in Europe that are choosing to so-called gold plate the Directive and impose a depository-like requirement, so the ones that are quoted often are Germany, Denmark, France. And there are some countries, most European countries have existing custodian/depository arrangements today anyhow. So we'll move on just to cover the full depository requirements. This is governed by Article 21 of the Directive. It's very clear that the manager needs to ensure that a single depository is appointed for each EU AIF that it manages. As I say, for most EU AIFs, there's already an existing custody/trustee requirement today. And the role of the depository is similar to that existing custodian, except that the depository is now required to perform a sort of broader range of duties, particularly around cash flow monitoring, which we'll come on to in a short while, and often referred to as required to take on the strict liability for loss of assets. There are some requirements for where that depository needs to be domiciled and what sort of regulatory standing and authorization that entity should have. But that's essentially the full depository requirement. We are somewhat assuming that there aren't too many attendees today that will be subject to the full depository requirement. But if there's any particular points that anybody wants to discuss on that, then submit a question and we can cover them later.
Okay.
Yeah.
Well,
if we want to do the polling question.
We'll just go back to a polling question around Depositary-lite now, which will come up on the screen there. This relates to your status in terms of what service you will want. So we're asking participants, do you need a depository? If so, yes, full or light, or no, seeking to rely on reverse solicitation. So we take those responses and then we'll look at those at the end. We'll just discuss those now before we go into the session on Depositary-lite. So just give a few. So it's yes, full depository, yes, light, or no, seeking to rely on reverse solicitation. Right, so Barry, could you just pull up the answers there? And what we're seeing in terms of this is that full depository is coming through 26%, yes, light depository 51%, quite substantial 23%. It's interesting, nearly a quarter on seeking on the light and reverse solicitation. So, Bill, so probably interesting sort of feedback just to feed into the Depositary-lite.
Yeah, well, I mean, it clearly shows what we'd expect, that more than half, albeit just more than half, is Depositary-lite, because that's the largest part of the segment for the European hedge fund industry is EU managers of non-EU funds. And obviously, we'll clearly have to touch on the full depository requirements as we go through these slides. And we're going to cover a bit off for the seeking to rely on reverse solicitation. It's really relevant if you're in a Depot-lite, an EU AIFM of a non-EU AIF. So that probably doesn't surprise us either for reasons which we'll come on to, because a number of firms are deciding to rely on reverse solicitation.
Yeah, I mean, I think that's fair. I mean, I think the biggest contention from a full depository perspective has been how the industry will handle it, being, as Bill commented on earlier, that most of these funds that require a full depository now have a custodian to date. So obviously the Prime Brokerage and the custodian industries have been trying to figure out how they deal with a model where the liability level has changed. And I think significant progress has been made towards that over recent months, and that agreements are pretty near to getting signed for various clients. So we can touch on some of the practical details later.
Yeah. Okay. So if we just go on to the Depositary-lite slide. This is where, as I say, you've got a non-EU AIF that's marketed by an EU AIFM through private placement. We'll come on to sort of what constitutes private placement versus reverse solicitation later. But assuming that you're marketing and therefore in scope of Depositary-lite, the requirements of Article 36 state that the AIFM needs to ensure that one or more entities are appointed to perform 3 fundamental depository duties. Now, these duties are also relevant to the full depository model, but clearly in the full depository model you have a single entity, single depository that needs to perform all of these plus other aspects. But under Article 36 it specifically states that the entities need to be appointed to perform cash flow monitoring, safekeeping of assets, which is both assets that are held in custody, so effectively financial instruments, and then other assets, OTCs and other non-financial instrument assets. And a general sort of oversight function, which I always describe as sort of layering on a trustee-type function to an offshore hedge fund. So it's oversight over the valuation process for the fund, subscriptions, redemptions, monitoring timely settlement of transactions, monitoring compliance with laws and regulations. The interesting ones within that, I think, are generally around monitoring compliance with any investment restrictions in the offering document. Is the most important, I think. But because under Article 36 more than one firm can be appointed to perform these duties, and the strict liability which applies to single depositories for EU funds managed by EU AIFM does not apply, it's generally sort of developed this moniker of depository-lite. So if we just turn the next page, the point to note about all of those 3 duties is that by and large, 2 of the 3 duties are performed today by a combination of, sort of prime broker, prime brokers, depending on the model, some cases some cash custodians, and the administrators. So clearly the prime brokers and custodians perform the safekeeping of assets, financial instruments today. The administrators, largely in the hedge fund space, perform daily cash flow reconciliation. It doesn't entirely meet the requirements of the cash flow monitoring requirements of Article 21.7, because there is a requirement now to monitor for unusual cash flows and so on. But the fundamental duties that are being done today, and the only one that's entirely new is the oversight duties. The directive itself just says that one or more entities need to perform those duties. It's silent about whether those entities need to be regulated, where they need to be domiciled, etc. The UK, and this is relevant, I think, for sort of firms considering UK firms to perform these duties, the FCA has created a new Part 4A FUSMA permission called an Article 36 custodian authorization. And the FCA is saying that if any UK firm is performing any one of those 3 duties, it has to hold this Article 36 custodian authorization. It becomes relevant when we start talking about sort of prime brokers a bit later on. We will cover on the sort of next slide, I think, the different models that are emerging. But one thing that's relevant is that when you look at the depository landscape today, I mean, in Ireland alone, there are about 18 different firms that act as a custodian stroke trustee that effectively will fulfill these duties. But there are a number of independent administrators that don't have an affiliated depository. And it's clear that a number of those firms are looking to establish a depository-like capability. So we make the point on this slide that unlike in the UK, other regulatory, other regulators across Europe aren't as clear about what their requirements are for firms undertaking these depository-like duties. And it's just worth noting that we're not going to touch too much today on what might happen post-2015 to sort of 2018 if the marketing passport of AIFMD, which clearly today only applies to EU AIFM and EU AIF, if it is extended to non-EU AIF, then there is a requirement that the depository needs to be domiciled in the domicile of the manager or the fund. So that's just one thing to be aware of as you think about the future as well. So on this next slide, we've got tried to sort of diagrammatically highlight the different models that have emerged, and I'll just cover some left to right. I mean, clearly on the left-hand side we've got all the various duties of the depository under Depositary-lite, and in Model 1 you've essentially got a single depository model, which is very similar to how a sort of custodian of an Irish quiff would operate today. That single depository is performing all of those duties, although for most hedge funds would delegate the safekeeping of financial instruments to the prime brokers through sort of a sub-custody type arrangement.
So I think the one thing to add there, I guess, if you kind of look at the different strategies that clients operate, to the extent that you're running something with physical assets, obviously agree with Bill, I think that the futures industry, for example, is now having to consider the fact that most of their assets don't require safekeeping in terms of the fact that they're not physical assets, and that they're in the other instrument bucket. So whether or not the models will differ by strategy, and whether or not, as an example, if you're only running a futures structure, you'll want to put it all in that scenario rather than needing to a point you're clearer for that function when you don't really have a traditional prime broker, I think will be interesting to watch.
Agreed. So that's sort of model 1, and then you've got model 2, which is essentially preserving the prime broker and sort of custodian's role today as the appointed by the AIF itself to perform the safekeeping of financial instruments. But all the other duties are performed by a depository. And then you've got model 3, which is the literal interpretation of Article 36, where you literally split out the various duties, and the safekeeping of financial instruments, which is performed today by the prime broker, will be performed by the prime broker. The administrator takes on responsibility for the cash flow monitoring and the record keeping of sort of other assets, and then a depository performs the oversight duties. I think the general theme in the market is, I think there's one, possibly 2 banks that have a strong preference for Model 1, and then I think in one case would only provide Model 1 solution. There are a couple of firms in the, well, probably more than 2, but at least one large administrator in Model 3, but the majority of firms are going to end up in Model 2, I believe.
Yeah, I mean, I think that's fair. I think that there is a mixture depending on the relationships that managers have with their administrators today, and that legal structure of that administrator in terms of whether or not they've got that trustee bank entity and want to perform this. And in fact, a number of them, I think, are planning, as this depicts, to put both the cash monitoring and the oversight into that trustee entity rather than keeping the cash in the administrator, which is obviously possible from a regulatory setup standpoint. And then you've obviously got that group of entities that don't have the benefit of a bank or trustee model as part of their group, which kind of needs to, or I think at least are having conversations. And I guess one of the ways in which still your business fits into this structure around how they offer a solution to the clients that they have to make it as streamlined and efficient for people going forward. I think we should remember that, broadly speaking, these are additions to requirements that firms have today. And I think, as we've kind of described it previously, there's a lot of operational pain and tweaks to existing services offered in these structures for these full funds, rather than kind of ultimately life-threatening. It's a little bit more of a legal agreement. It's potentially another service provider. It's potentially a bit more transparency and so on.
I mean, I think if you're a manager, it really, the starting point is to understand. I mean, I think in most cases it's given that your prime brokers will be prepared to continue to act as they do today and perform the safekeeping of financial instruments. So you may have a choice, an option that you prefer a Model 1, and there are reasons for and against that. But largely it's going to come down to your starting point is what your administrator or an affiliate of your administrator is able to support. And then you've got a question about whether you want to use an affiliate of your administrator or go for an independent option. And clearly INDOS is one, but there are others. I'm not here today to promote INDOS only. There are at least 3 other firms that can slot into this model and provide an independent alternative to your affiliated depository of your administrator.
I think some of that will come down to how managers are getting their legal advice in terms of how they want to think about segregation from a sort of conflict, from a separation of on a hierarchical basis of functions and so on, and how they choose to interpret that in conjunction with their law firms as to whether or not they're comfortable with separate legal entities, affiliates of the same group, and so on. Yeah,
and it's probably worth noting, and Emma, you could probably comment on this as well, because there's often, when you come to Article 36, the directive says that entities need to perform the duties. It just so happens that UK entities need to hold an Article 36 custodian authorisation. But there is a sort of misconception that you have to appoint depositories, which is not the case. It's just firms have to perform those duties. And many people say to me, well, why doesn't my prime broker act as a depository? But I'm unaware of prime brokers. They'll perform the safekeeping duties, but I'm not aware of any prime broker that's going to act as a depository.
I don't think I've heard it in the industry. I guess there's a difference between do prime brokers want to consider it from a business perspective, whether or not their legal structure allows them. So to the extent a prime broker is I guess, structured involved. For full depository, it depends on how the prime broker is legally structured, right? Are you a bank? Are you a broker-dealer? Are you an EU credit institution? And so on. And obviously, are you in the jurisdiction of the funds? I think for Depo-lite, the problem becomes we live in a multi-prime brokerage model or world these days. And so it's much more difficult for a prime broker to be able to say, I would like to help you and perform cash monitoring or oversight, but they actually don't have visibility over all of the accounts. You really need that, or in the industry has come to the conclusion that you really need that third-party entity that can see all of the movements across the multi-prime brokers. Otherwise, you're going to be in a situation where the various prime brokers are providing all their information to one other entity.
Yeah. Okay. So we thought on the next slide. Sorry, I'm being told there's a polling question.
Right, that's a point to cut in then and just go to that particular question. So this is really a question around the depository-lite service providers, and the Bill's point has been a number of providers offering services there, but has your firm, if you decided on depository-lite provider, who they'll be? And that's quite a simple yes or no answer, and I'm wondering if we'll get a 50-50 split on this one, or whether we'll see some trends towards a national provider. So if you could poll now, if you've not done so already, and then we'll deal with questions on responses towards the end. Okay. Oh, and another question is relating to the model that firms are considering, whether that model will be single depository, the hybrid model that Bill described, or the multi-firm model. And again, we'll review those points at the end of the relevant session.
Okay. So yeah, so we thought we'd just take a step back and ask the question, or really just consider the question about whether depository-lite is required. So as we said, the Article 36 depository-lite regime only applies if a non-EU AIF is being marketed to EU investors. I mean, many that are attending today will probably be aware that the broad definition of marketing under the directive. I think the point to note here is that, clearly, in my opinion at least, the definition of marketing is fairly broad. It's brought marketing up the regulatory radar in the sense that all the EU member states are having to consider and put into national law sort of what their view of marketing is and so on. Now, the reverse solicitation does not constitute marketing. There is fairly or scant guidance. The FCA is a notable exception to that as to what constitutes reverse solicitation. But if you are relying on reverse solicitation, and as Bobby said at the beginning, that's a sort of means you're not marketing essentially, and you can articulate that in your regulatory business plan as part of your VOP application, then you don't need to comply with Article 36. Now, anecdotally, and I think we've already seen, it's a fairly high percentage, 23% in the earlier poll, said that they were going to rely on reverse solicitation. The feedback that we seem to get from various sources, whether it's firms like Cordium or prime brokers and lawyers and so on, is that anywhere between sort of 50% to 2/3 of managers are taking the position that they're going to rely on reverse solicitation. I mean, Emma, you've probably got some points to make about sort of Europe as a whole as a market and so on. But
sure. I mean, I think there are lots of reasons why people aren't necessarily choosing to take advantage of appointing the depository-lite and looking to market in the UK, and they're not all necessarily, I'm trying to avoid the rules. In fact, there are very valid reasons why people won't look to appoint a depository-lite. The obvious one would be, my fund is closed, I'm at capacity. And why would you add an additional burden if you don't actually need to raise additional funds? I think there are also scenarios around how big is your fund and what is your current target market, i.e. if you're only targeting investors outside of the EU, including the UK, maybe again, if that's where your marketing plans lie for the next 12 months, again, why would you go down that route? Obviously, the UK is by far and away the biggest market for offshore investments in EU based on various people's surveys, and has been. Switzerland being the second biggest, and obviously we don't concern ourselves with Swiss investment as part of AIFMD. So I think there are various EU interpretations, and I think it in part depends on how conservative or regressive both your own internal thoughts as a firm are, as well as the legal advice that you're getting as to whether or not you need to or want to go to the additional effort, whether in the short term or the longer term, of appointing people for Depositary-lite and looking to formally market under a private placement regime in Europe, in terms of the weighting of where your assets might come from.
Yeah, I mean, I think there is definitely a risk appetite question here,
yeah.
And clearly having the building blocks in place with Depositary-lite helps you mitigate that risk. I mean, it's one of these things that, is it going to be tested? I mean, are the regulators really going to be, focused on this and do spot inspections, or is it going to be a case of, you lose an investor money, then they find a way to bring a claim against you for not following the marketing rules? I mean, I think that's where the risk appetite question comes in. But
very much so. Very much so. I completely agree. I think the last kind of comment that we've heard from clients is, I'm not saying I'm not going to do it. I'm just not sure I'm going to do it for the 22nd of January. So because there isn't necessarily a consensus in where the models will come out, because we're all still in the discussion phase. There are draft legal agreements out there. There are draft proposals and costs from the various parties, and nobody necessarily knows where the majority will end up. From a practical perspective, maybe people will wait until the spring or the summer, and to earlier commentary, a month before when they might have to change their mind, or they'll do it in the fourth quarter when they maybe are going to do any formal marketing in 2014. So I think there's lots of opportunity to wait, even if you're risk averse, just to see where the kind of average model comes out.
Just the hidden danger in that is possibly not making a decision. It means that when you do make a decision, you get caught with the whole depository process, and you get caught with the marketing, the prospectus disclosures, you get potentially caught with the Annex 4 reporting, and so on. So the decision to switch on marketing is not necessarily a quick decision. It needs to be properly planned and thought through, and there's a proper lead time to that.
Completely agree.
Yeah. Okay. So we were just going to cover some of the operational sort of implications, and to a degree it sort of is driven by whether you're in the full depository or depository-lite regime. I mean, I think in my expectations as a depository-lite firm is that it's largely a case for I mean, clearly you're going to have to appoint a provider. In almost all cases, you're going to need a new provider, even if that's just an affiliate of your administrator. It's still a new relationship, but you're going to have a contractual agreement for the services that are provided, irrespective of which model you're pursuing, unless you're outside the scope of the depository requirements. But there shouldn't be any need operationally for building of trade files and things like that. It's really for, in my view at least, the depository firms and prime brokers and administrators to work together to produce the solution, and then just report the results to the manager. I mean, clearly there are some requirements from a due diligence perspective for the depository will need to satisfy itself that it's the manager that it's willing to take on the business for. But in my view, the approach that we're taking at least is, well, provide the due diligence questionnaire and so on from the manager. That gives you 90% of what you need as a depository-lite firm, and then it's a follow-up conversation focusing in on any particular question areas. But the actual day-to-day getting it up and running is just INDOS, for example, in our case, coordinating with administrators and prime brokers. So, as we mentioned earlier, the AIFMs themselves are required to ensure compliance with the directive as a whole, and clearly they need to establish or assess providers and be comfortable that appropriate firms are being used. Hence, the reference earlier to the due diligence requirements with the SCA. I mean, I think clearly there's going to have to be some disclosure in the offering document about the roles of the providers. And when it comes to depository contracts, they're typically going to be between the tri-party between the AIFM, the AIF, and the depository. There are a number of existing sort of trustees, as I say in the Irish market today. So these aren't entirely new agreements. I think there's a level of frustration in the market that there aren't more AIFMD depository agreements out there in the market, but they're starting to emerge. And they really all should be fairly vanilla, straightforward, negligence standard type agreements. I'll let Emma talk about prime brokers and so on, but different prime brokers have different views about whether any addendums are required to prime brokerage agreements to reflect the fact that they're going to be performing the safekeeping of financial instruments, if indeed that's the model that a manager selects. I don't know if there's anything you want to...
Yeah, I mean, I think to touch on sort of the way in which we're hearing that Depot-lite will work and how it will impact, client, yes, completely agree with Bill. I don't think everybody is there yet in terms of what the agreement will look like. There is obviously a requirement, or at least it feels like there's a requirement to formally acknowledge the appointment of the entity as asset safekeeper if it is indeed to be the PB. Whether that comes out as a one-way notification or a requirement for a signed document, I think may well end up differing by prime broker. I think outside of that, the predominant requirement will be one of transparency to the other providers from the prime broker, and indeed from whoever is providing the cash monitoring to whoever is providing oversight. So to Bill's point, this isn't necessarily new information that's being produced. It's about the provision of that transparency between the various entities performing the function. So that could be an administrator performing cash oversight, sending reports to INDOS if they were appointed as, let's say, the oversight function. Likewise, it could be the prime broker providing information to the administrator on cash movements within the prime brokerage account, and so on. But these aren't brand new technical bills. This is generally information that those entities produce today. Obviously, this is different from the potential for the requirements under full depot, which I think we're going to talk a little bit about too.
Yeah, okay. So the next slide.
So I guess what we're going to kind of touch on here is, from a prime brokerage perspective, or at least what we're hearing, the kind of how the industry is coming out from what our clients are talking to us about, is kind of how does this really impact us day to day? And I think ultimately a very large percentage of what's occurring, particularly in the full depot world, is not a huge difference to what's done today. A custodian exists. There are agreements between those custodians and the prime brokers. There is the provision of certain types of information, certain amounts of due diligence and reporting are required. And all of that remains the case under AIFMD, but generally speaking, the depositories are requiring it all to be enhanced. There's obviously the legal requirement to deal with the issues around the change in liability levels. And I think, again, the industry will come out with different models here, one obviously being an indemnity structure, the other being contractual discharge, and potentially a hybrid of the two models where you have a contractual discharge that's covered by an indemnity if that contractual discharge was proven not to hold up in court. So I think legally there are three different structures that we're hearing being discussed, and it's simply possible that the different prime brokers will come out with different ones. I think from a due diligence perspective and a reporting perspective, it's enhancement. It's to Bill's comments at the beginning, where the AIFMD requires those depositories to do additional due diligence around various aspects of the fund's operations. That therefore requires any other service providers to those funds to provide that additional colour. So enhancements on how those depositories look at the prime broker sub-custody models in the assumption that business as usual continues and the prime brokers continue to hold assets is an obvious one. Likewise, the cash movement process and other activities within the client account is another. So due diligence, reporting, legal documentation, and that sort of ongoing due diligence. So site visits and things, again, not unusual today, but I think there will be a concerted sort of upstep in the frequency of their activity and the diligence of that activity by the various depositories on us as prime brokers.
Okay. Thanks very much, Bill and Emma. We'll come back to you with questions and from the audience. Please feel free to send more questions through. We've had some come through already, and we've got a few at the moment. Happy to take some more in the time available. I think just review the two of the polling questions in responses, and we just comment on those. So in terms of the selection and determination of a service provider, a depository service provider, we ask who has and who hasn't.
Wow.
Yeah, I guess it's probably going to be 50-50, but in fact it's more 40-60, which is a little bit of a surprise. So 43% have decided on the Depositary-lite and still 57% out there. So Bill, it's quite a market to go for.
Well, it doesn't surprise me actually. I mean, certainly the feedback that I've had in the market, I'm surprised actually the 43 is as high as it is, but there we go. As you say, a lot to go for.
I mean, I guess some of that could be an assumption, right? That kind of people are talking in the industry about who's going to provide what, and to build, you know, we were talking about the model options. I'm making an assumption that I'm going to ask my PBs to do my asset safekeeping. I'm going to make an assumption that my admin or their custodian bank might do cash and or oversight, or I don't know if third parties out there. Kind of, I've got it in my head, but I haven't actually appointed anybody yet.
Yeah, I mean, we've seen business cases being drafted to the FCA which indicate one of two, and you know, and it may be the case that both or one of them are pending authorisation anyway. So it's important to sort of, you know, not commit at this stage, but nevertheless there seems to be a clear mind in terms of thinking where they go. Okay, and then the second polling question dealt with the models, and this is really around the single depository or the hybrid or the multi-firm. There's quite a squeeze there actually, quite interesting.
Interesting. I mean, one would think that the model, I'm guessing, if we don't have time for another polling question, but the single depository is clearly going to align with the high percentage we store for full depot, because that's the only model that's available.
Yeah.
What's surprising is there's a hybrid model. I mean, it's perfect news to my ears. Model 3, multiple firm. I mean, that is the one that results in the least duplication of effort and is lowest cost. We haven't really covered costs, but maybe there'll be some questions on that. But in reality, I think if you're depot-lite, it's most likely going to be Model 2 for most providers.
Yeah, which kind of makes that stuff interesting. Yeah.
Okay, thanks for that feedback, and possibly a chance just to go through some of the questions that we received through the polling. I know it's been covered. It did come in quite early on in the stage of proceedings, but it was really just around clarification of full deposit and depository-lite, and when you can and when you can't. Bobby, perhaps you could try it, and then Bill can. And then we can comment if need be. Are all EU and non-EU ACE under full depository, or can non-EU ACE be subject to depository-lite, or when can they be subject to depository-lite?
Well, the very short answer, as you say, we have covered that, but just to reiterate, for every EU ACE that you have, you must appoint a full depository for that ACE.
If you're an EU ACE.
Sorry, of course, if you're an EU AIFM. And again, if you're an EU AIFM with non-EU ACE, then one must appoint entities to conduct the depository services.
If you're marketing.
If indeed you're marketing.
There's lots of ifs.
Yeah. You know. But in short, you can have, this is alluding to the multi-model that Bill mentioned.
And one of the questions, and this is a throwing out there because it's one of the last recent ones that come in, but I think it's relevant to that, my comments around the VOP, is this: who do you put down on the depository on the VOP form if you've got a multiple firm model in the depository? But I'd take that to be the depository.
Well, no, because depending on the model, I mean, the form, and I think the FCA, I don't know if they've published an updated form, but that's more of a splitting of Article 21.8, the safekeeping of financial instruments between assets held in custody with the PBs and other assets which will be performed by your depot or administrator. But nevertheless, the form allows you to put any one of those models you can put into that form.
Absolutely, yes, that's quite right. So, as we mentioned earlier on, one needs to be fairly advanced in your contractual negotiations. If you have a number of depositories in mind, try to narrow that field down to as small a number as you can, and be just very clear and transparent in your disclosure within the variation permission that in terms of where you are in those contractual discussions. So the FCA may well reach out to those depositories or providers on your shortlist. So narrow it down as best as you can, but disclose in full within the variation permission form the status of those negotiations.
And another question, again, is around the VOPs. Interesting that these ones coming in, is just to do with the liability. If depositories have got strict liability within these relationships, and perhaps holding off and making a commitment to actually acting as a depository, what should firms be putting in their offering memorandums and in their VOP forms and so on to actually communicate who the depository will be.
But I think there's a part in that question that is, are we looking at Depot-lite or are we looking at full depository? Obviously, the strict liability element, my understanding, obviously doesn't exist in the full depot world. So we're obviously happy to deal with, contractual discharge or indemnifying the depositories if we take on that, but that's only for EU8. I don't think it's a debate for the prime brokerage industry that has to be resolved. Otherwise, the prime brokerage industry is making a statement in relation to onshore fund business that I don't think it's making. Right, we were the PB industry and the associations affiliated with that have been working very hard with the custodian industries to figure out what that looks like. And as I said, there may be several models, but there will have to be models. Right, this is business that is decently is a sizable industry, right, from an onshore fund perspective. So I think it has to be dealt with. Obviously, if we're being appointed Depot-lite, the strict liability piece is there.
But then it's worth noting that clearly the early adopters of EU8 from the EU8 have already resolved that question. They would have had to if they'd become authorised as AIFM.
Yeah, I mean, I'm only aware of one or two, and obviously those models I think have been kept relatively, or at least I'm not aware necessarily of how they've been resolved. So I know how our models all look.
We've heard, I mean, there's not a hedge fund issue, but we've heard in the real estate market there are, they're not private equity, and if they're onshore funds, then they need full depository, and people provide their services in the regulated fund market, but haven't necessarily thought about providing their services in the unauthorised market, and so there is debate going on, and it could be true, I don't know, the person's strategy and so on, but more complicated strategies and something like that. Could people, the depositors may want to spend more time understanding what risks they're taking on, which is slowing down the process.
I mean, I think practically, I mean, I speak for a hedge fund perspective, but if you've already got a custodian for EU fund today, if I were putting the VOP in, you'd put that custodian down unless you wanted to change your provider. I mean, what the contractual rate
for Depot-lite?
No, for full Depot.
Well, but that's the only entity it will be, right?
Unless you change provider, yes. So you've almost got to, the manager's responsible for ensuring compliance with the directive. The manager is clearly interested in what the contractual terms agreed between the depository and the PB, and particularly where there's a discharge of liability. But in some cases, unless you're going to change your custodian or depository relationship, you don't have a choice. Yeah. So you can walk with your feet, but that's the reality.
It's a good point. The legal agreement between your depository and either your clearer or your prime broker, in terms of its legal structure, is irrelevant based on the fact that your depository has to be in the jurisdiction of your fund, and that won't change. However, a lot of the liability is dealt with legally. Yes, you're right.
All I think you can do, is putting a sort of my ex-manager hat on, is put as much pressure on everyone here, but put as much pressure on your providers as possible to get to source out the solution.
And that's very much the message we've been conveying to our clients also. Absolutely.
Okay, just taking another question, Bill. I'd like to take this one to yourself. I know you've not had a chance to look at this. It should be relevant to your business model. Thinking operationally now, in around operating a depository-like business, how will you be looking to ensure that the firms that you're acting for are acting in compliance with the AIFMD? And the question's not coming out, how deep are you going to go?
Yeah, it's a very interesting question. I mean, I think if you canvass the depository market today, the interpretation of the subset of Article 21.9, which deals with compliance with laws and regulations, they'd say their view is compliance with the offering memorandum of the fund. It's quite different. When I first started looking at this about a year ago, I thought, well, I'm going to have to go into managers to get myself comfortable that they are in compliance with the AIFMD, but that's a very broad. We've got a halfway house. I mean, the industry is going to be, I think, referencing this to the offering memorandum, but what we plan to do is understand a bit more about the manager, and through sort of regular quarterly sort of update reporting meetings with the manager, just understand developments in their business and just get a feel for issues in their compliance program and so on. It's not a sort of deep dive going into get reporting from their compliance consultants or anything like that. I'd be surprised if any depository is going to take that approach.
Would they place any reliance on the existing compliance infrastructure there, or indeed the fact that compliance consultants?
I think it's partly a part of, different firms have take a different view, and different firms clearly have different sort of internal policies, procedures, risk appetite, and so on. But my view is that that's part of your onboarding for the client. Do you want to do business with that client? And clearly, if they've got a robust compliance framework in place, it gives you the comfort that it ticks that box. But that's not INDOS in our case going into the manager and saying, right, well, we want to see the last 2 years' worth of compliance reports and so on. Okay. Different firms might take different approaches.
Okay. And also, you've been through the mill with the SDA in terms of the authorization process. So, from what you know, how are they going to regulate you? Are they going to sort of use you as a policeman of the industry?
It's a very good question. We don't really know. I mean, it's interesting that there's nothing in the directive itself which says that the depository needs to sort of whistleblow, if you like. One of the questions that the SDA asked us through our application process is, well, if you identify something that isn't, which you don't agree with as a depository and it isn't resolved suitably by the manager or the board of the fund, would it get escalated to the SDA? I thought that was quite interesting in the sense that the SDA wants to ultimately be the sort of receive reports from the depository if things aren't operating as the depository would expect. But they haven't. They wanted to see a compliance monitoring plan as they would for any new registrant or applicant, but they haven't said they're going to come and visit every quarter or anything like that.
I think it's interesting that there are different business, because there's been different business models being established. And maybe if you compare it with the UCITS world, and when they do regulate the depository, they do kind of use them, I think, a little bit in that way. But of course, perhaps didn't have interaction for a number of years with the depository that some of the previous regulatory regimes have, or they looked at sort of hosted NCD type models and used those to sort of. It'd be interesting to see how they evolve their supervisory techniques. Because actually, at the moment,
I mean,
probably a parallel to draw.
But I think that's the case across the industry, right? There's a whole bunch of different entities, and as was highlighted by Phil at the beginning, that the prime brokers will need new licenses too. So, the monitoring program for the alternative industry, whether the fund managers themselves, some of which obviously get regular area visits, the prime brokers, which obviously do, and the new entrants to the market, I think how that will work itself out will be interesting across the board, and as a much larger question.
Okay, Emma, just picking on the subject of authorization and prime brokers, we've had a question come through around safekeeping of financial instruments and whether or not any PBs are actually saying that they do conduct that service.
Yeah, I mean, I've been having conversations with our clients, and I'm sure my peers at the other prime brokers are doing the same. I certainly haven't heard any prime broker say they're not going to. Now, I haven't spoken to all of them, obviously, so I can't say that categorically, but I think the expectation from our client base is certainly whether it's full depository or depository-lite, which is obviously where the safekeeping kicks in, is normal course of business for a prime broker. Clients don't want a huge change to normal course of business, so I'd be surprised to find one that didn't. Obviously, again, the strategy specific, right? So if you have physical assets, yes. If you're futures only, there is a question over whether or not, one, do you need to appoint somebody for the asset safekeeping, so for 21.8A, or do you only need 21.8B? But if you do need to appoint someone for 21.8A as well as, do you want to employ a second provider when you actually don't have physical assets for safekeeping, instruments for safekeeping? And I think that's a question mark. I've certainly had conversations with clients and lawyers about it that I don't have a categorical answer to yet. I don't know whether or not anybody else does.
Okay, there's still time for probably just a few more questions if they come through. One of the things that is sort of onboarding process. How long, sitting here in nearly January, but in the application, how long will it take to, in your views, to sort of onboard the depository-lite into the become operationally compliant? Can firms, a question we were going to allude to earlier, and some of we're going to deal with, but can firms do it in the 6 months time frame? Is it a much shorter process than that? What sort of is that timeline, if you like?
Yeah, I mean, I think it's going to be provider specific, in my view. I think, as Bobby mentioned earlier, I mean, the majority of EU AIFM and non-EU AIFM are going to probably put down the 22nd of July next year as their elected date for authorization. Certainly the approach that we're taking is, I mean, I just generally think that there's going to be, whether it's 50% or 2/3 or even less than that, there's an awful lot of funds that need to be onboarded in the industry for Depo-lite. And the approach that we're taking, and I've heard this mentioned by other firms, is, well, you actually have to start onboarding. You can't onboard that number for big bang July the 22nd, ready for July the 31st. So we're working on the basis of saying, you know, whatever box we're on, we have line of sight as to what our demand is. Start onboarding in a third in May, a third in June, a third in July. People don't start paying in July, but I think the managers need to be in compliance with the directive and be happy they're in compliance with that as at the 22nd of July. So if you had a little bit of, you know, getting used to the model for a couple of months without, you know, the depository being frankly on the hook or anybody paying for it, at least operationally you're ready. And I can't see why any sensible depository wouldn't take that approach, unless they're just got mountains of people and they can onboard lots of funds in 1 month. But I just don't see how you can do it.
I think that's fair. I think it's also, I talked earlier about the fact that transparency is one of the big things here. From a depot-like perspective, it's a case of who's providing who with what reporting to make sure that everybody can perform the various functions they've been appointed to do. And I think for a lot of the prime brokers, everything that they may be required to tweak, adjust, build from a reporting perspective, and indeed the same for admin, they'll be doing for full depot. So that kind of piece is covered off. You've got a couple of legal look at contracts to potentially tweak or negotiate. You might have a couple of one-way bits, a couple of two-way bits, and then it's connectivity, right? It's what reports do the person doing oversight require, the person doing cash monitoring require, and who's providing who with what. So it's kind of a bit of a coordination and sharing exercise, I think, between your third parties. I'd like to think that doesn't make it hugely time-consuming, but famous last word.
The variation process is asking for attestation of systems controls in place in preparation readiness, and that implies some form of tested processes, parallel processes, or mode of operation which is consistent on the directive, so you are fully compliant on July 22. So that's that all needs planning, all needs thinking through.
Yeah, I think realistically, if you're not there by, well, you actually per the AIFMD Q&A from the SCA, you've got to be there, notify them by the 21st of June, if I remember rightly, to be ready for the 22nd of July. But I think some managers are just saying, well, we'll just have a marketing blackout till September perhaps, so you've got 2 or 3 months to get it in place if the capacity is there in the market. And I'm not scaremongering, but it's a big unknown whether there'll be a capacity question.
And the other thing that seems to have gone a little quiet in all the conversations, but perhaps it's just never been asked, we started the conversation on depository all around costs and what's it going to cost us and so on. And then with lack of capacity in the market, is that going to drive up cost? Is that going to cause, have you got any view of where costs are sort of bottoming out at in terms of?
Oh yeah. Well, I think it really depends whether it's firstly full depot or depot-lite. Clearly full depot where, and then you've got 2 variants of full depot, whether you've got the depository discharging as liability or not. Clearly, if they discharge, you'd think it would be cheaper than where they're taking on the strict liability for loss of assets. But nevertheless, even when you're going for Model 1 of Depot-lite, Model 1 of Depot-lite, bear in mind, a single provider, and a full depot model where the depository is discharging its liability, fundamentally there's not a lot of difference between the 2. So the pricing is about the same, and it's, you hear room 4 to 5 basis points, and the cheapest of those 3.75. Depot-lite, for Model 2 or Model 3 should be the cheapest of all of them, but Model 2 and Model 3, it depends which provider you're talking to, but I don't think firms should be paying more than 2 basis points. I think it should reduce as assets grow. Firms should be willing to talk about fee caps, not many of them are. But the interesting thing for smaller managers, you have to be about $250 million to be above a minimum fee threshold. And the minimum fees in the market for Depot-lite, I can't speak for full depot, anywhere from, I think cheapest I've heard is 36, and most expensive is $55,000. So you have to be a reasonably sizable fund to just swallow that minimum fee.
Okay, thanks very much, Bill, for that. I think probably that's time we've got there for questions. So thank you for everybody who submitted their questions through to the webinar. I think, again, a very interesting discussion around some of the requirements. Again, the reminder, there's not much time to get a lot of things done, but I think with proper planning and support and thinking through these processes, no doubt those things will be achievable. A reminder up on the screen of our next webinar, which will be early in the new year, in January. We're having another perhaps the elephant in the room people don't want to talk about, which is Annex 4 reporting, which is another matter that's going to need to be addressed. And then well, probably depending on SDA guidance and clarifications later in the year, rounding out our update on remuneration. So I'd like to thank all our participants for their time today, given their time here, and also for our supporting in the whole webinar itself. Thank everybody on the call for their questions, and this is to close out the webinar on depository services.